Good morning, everyone. Good morning, Sarah.
Good morning, Jackie. How are you this morning?
I'm very well. The sun's out and all is good.
Yes.
Now, we're back again for one of our podcasts, and we're continuing with the theme of myth-busting in the law. So this time we're looking at children's matters and how applications in relation to children are dealt with through the courts, and the attitudes which are formed, and also the preconceptions which a lot of our clients come to us with. So I think from our common experience, we have a lot of clients who come to us and say, I'm seeking contact with my children or my child from a previous relationship. I've separated from the parents, but I'm presuming that I haven't got a chance because I'm the dad, I'm a man. And isn't it always the case that the woman, the mum, ends up with the children?
Yeah.
So I think you've had that.
Yeah, absolutely. And I think it's one of those, again, that dates back because there was a time, probably in the not too distant past, when it was assumed that mum would have the children most of the time and they would stay with dad typically every other weekend. That was the general norm. But there's particularly in the sort of last probably 5 or 10 years been a massive shift. And the assumption now is more towards a joint arrangement, a shared care arrangement, whereby the children get to have a quality relationship with both mum and dad, and they're on an equal footing. There isn't, both of them have parental responsibility. Neither of them has parental responsibility which is above the other.
No.
And there's definitely a shift towards co-parenting and the benefits to the child of parents working together even though they're separated, and spending quality time with both parents.
Yes, yeah. There's been a real trend in that direction, and the law reflects it as well. And I think also it's about the cultural changes. So historically, typically, it would be, as a stereotype, it would be that the husband went out to work or the man went out to work, and that the mother was at home looking after the majority or all of the childcare. And so it tended to flow from that there was stability, there was consistency with the children being with the mother.
Yes, absolutely.
And therefore, so the father then had to pursue that contact.
Yes, yeah. And I think, again, particularly when children were younger, there was the assumption they need mum more than they need dad, in terms of breastfeeding and so on. But as they get older, they would spend more time with dad. But I think with the cultural change in terms of parental leave, and I know several people who have shared their parental leave, and it hasn't just been mum taking the whole of the maternity leave and dad's been out of work during that time. I think that's a realization of society that actually children need both parents, and they are equally important. They offer different things, but it is important that the child has a relationship and a meaningful relationship with both.
Yeah, that's right. So it comes down to the shared care presumption more so, doesn't it? And also the fact that the Children's Act 1989 is very much about it flowing from the child. So what the child's entitled to, what's in their best interest, as opposed to the competing nature perhaps of the respective parents.
Yes.
And that's really how things have been dealt with for quite some time. As you say, at least sort of 5 to 10 years now, there has been a shift. And so we're able to quite confidently say to parents, perhaps especially dads who come from that perspective of feeling disadvantaged, that the court will look at this very clearly from the perspective of the child. And the fact that if at all possible, if it's in the best interest of the child, you will have a role in their life, you will be part of their life. And if it also works practically and can be done in the best interest of the child, then you share that care. And so there isn't any disadvantage in one direction or the other. I think also the language has changed a lot, hasn't it? So it was very much a polarized situation where we would be talking about residence. Prior to that, we were talking about custody. So access. And it was all very much about one particular parent having all of that, and having that control, as opposed to now it's about living arrangements, shared living arrangements. So you'll have the language now of the children's arrangements orders, that you have the child living with one parent, subject to spending contact or living with the other parent. So it's that whole mutual arrangement. So that's definitely moved on.
And a reflection that even if the time can't be shared equally, because some people's arrangements in work and so on mean that it's not practical for the time to be shared
Absolutely.
equally, but it can still be a shared care arrangement whereby the child lives with one parent at X time, the other parent at Y time, rather than they are living with this parent but they spend time with this parent. It's very much in the language, and but also that language should be reflected on the ground that both parents have a role to play.
Yes, that's it. And it's not a mathematical calculation. So
No.
it's not that it has to be exactly 50% of the time. Let's get the calculator out.
Yes,
it can be a shared arrangement that works within the context of that family, as you've said, what works for them.
Particularly as a 7-day week is quite hard to share equally.
Yes, yeah, 8 would be easier. Yeah, but not so good work-wise. Yeah, so that would work. And it's also about, I think traditionally it used to be the case, as we say, the predominance apparently of the woman being the main carer and the children being with the woman. It was also really about, to a great extent, continuity and consistency. And that's also a little element still of actually, where are the children? So it may be that the children are with the mother. It doesn't mean per se that the children should only be with the mother, but a court may look at that as being, well, actually, then can there be a shared care arrangement? Or in fact, you know, is it actually in the best interest of the child for there not to be a significant change because they are with the mother, or they are with the father, if they're with the father predominantly. So some of it is actually to do with the stability and the existence of a situation that's not going to disrupt the children to their detriment.
Yes, yes, you're right, absolutely. Is looking at what works for the child. I think the other misconception that follows on from that is in relation to child maintenance. And often we hear that the parent with whom the child isn't living, or who spends less time with the child, hasn't been paying maintenance, and therefore their time should be reduced more. And it's quite clear, and it has been for some time, probably forever really, that they're not linked. What is in the best interest of the child is not linked to how much money the person spending less time with them is paying towards them. Might be a reflection of their commitment to the child, and so on, but it is still assumed, whether maintenance is being paid or not, it's still assumed that the child should have a meaningful relationship with both parents, which then leads on to having a meaningful relationship with both sides of the family, because it's not just seeing mum and dad, it's their extended family as well, isn't it, that they need to have a relationship with.
That's it. So it can be indicative of showing responsibility, but it's not the be all and end all, is it? No. And I think the courts are very reluctant to be seen as in some way rewarding a parent who's accusing the other parent of not paying maintenance by then adjusting the contact, because the two shouldn't be connected. Invariably, they get connected in some way because of the issues which are arising. But the reality is it shouldn't be a carrot and stick situation.
No, absolutely. The next thing I think we hear, or we're often asked about, is how the behaviour of one parent might affect the time that the child will spend with them. So it might be that historically one parent has been violent to the other, or controlling, or been using drugs or drinking excessively, and how that behaviour will affect the arrangements. Some people assume that will be an absolute bar to any contact, or the child spending any time with that parent, but that's not the case. And again, it is still assumed the child should have a relationship with them, but it must be a safe relationship. So the court will assess, how do we make that safe? It might be they start in a contact centre and it gradually progresses to less supervision and then moving into the community, but still starting at a contact centre. But it won't mean that it's an absolute bar, and it won't mean that that contact won't move forwards in the future.
Yeah, absolutely. And when you're within proceedings, of course, on every occasion that you go to court, the court has the ability and has the discretion and has actually the need to look at contact on every occasion. And that's the presumption. The default is what sort of contact can be achieved here, even if there is a dispute and there isn't an ultimate agreement between the parents, what sort of contact can we achieve? Because it could be that the best we can achieve is at a contact centre, supervised, monitored, some sort of level. So even if there are those background significant issues in terms of behaviour and maybe relating to lifestyle choices, etc., it doesn't mean that's the end of the contact happening. There's usually things that can be put in place. Quite often in cases, I've had situations in which one parent has alleged behaviour against the other, and quite often that parent will accept and make the admission and say, yes, I put my hands up, I do have a drink at the weekend, I do this, etc., but it's not going to impinge upon my ability to look after our child safely. But if it does actually give you confidence and reassurance and instill some trust, I will give an undertaking to the court, a solemn promise that I won't do this, during these periods of time, or 48 hours before I have contact with the child. And the court's really quite open to that, because what the court's looking at ultimately is not trying to create perfect parents, because none of them are. none of our clients are. We're not. I'm not. No. I speak for myself.
Yeah, I'm not.
We just do our best, don't we? It's just best endeavours. And obviously, there's different levels in terms of welfare issues, in terms of lifestyle choices, and things which could actually affect the well-being of a child. But there are certain things which, we all do, which is part of not just our makeup, but how we live as a family.
Yes.
And if the court can see that actually, even if that appears to be intrinsic to that parent, as long as there are safeguards and there are things being put in place, which means they appreciate that the child comes first, then contact will happen still. Yes. All you have to be is a good enough parent.
Yes, yeah. And I think in terms of contact starting at a contact centre, which might be because there's been violence or because of drug or alcohol use, it's not usually the end of the road. And during the process, there will be reports of how the contact is going, probably from the contact centre staff. CAFCAS, the Child and Family Court Advisory and Support Service, can look at that contact and suggest how it moves forwards. But it might be that there needs to be drug testing or attendance at a domestic violence programme, and the court will look to see what needs to be put in place before that contact can take place safely.
Yes.
And then can make an order for it to move on and be more meaningful, because contact centre isn't going to be a quality contact in the long term.
No, not long term. No.
It's a good thing to keep the relationship going.
Yeah.
But if it can move on to better contact and be safe, then that is what the courts will strive to achieve.
Yeah, that's right. And what we're really talking about there also is then the relationship, the working relationship between the parents growing. Yes. So that actually they don't need the third party intervention. The safety's there. The welfare issues have all been dealt with, and it's about the two of them knowing their child best.
Yes.
So even though the court will apply the law, the court at the end of the day doesn't know that the child in question. It's based on evidence and that which is told to the court. So ultimately, if the parents can make that decision between them and consult and agree things between them, then that's got to be in the best interest of the child.
Yes.
Also, Sarah, talking about historical allegations where they keep popping up, basically those allegations keep being raised by one parent against the other, perhaps as a block, perhaps in terms of one parent being hostile to the concept of contact, but perhaps also because there is something there which hasn't actually been addressed fully. Yeah. So when we do sort of get into that area, then we're looking at what other evidence may be required if you're within contested proceedings. So the court's looking at these matters, and then you're saying, well, does there need to be a finding of fact hearing? Does there need to be evidence that's actually tested as to whether, is this allegation actually truthful? Is it based on something? Is there a foundation? Is it relevant?
Yeah, and is it?
There can sometimes be a perceived risk or something of that nature, but it may not be relevant actually to the contact issues and the welfare of the child.
No, and is it a genuine concern of the parent who's raising it, or is it a way to try, as you say, to block that contact, because quite often we see, or I do anyway, that there's been an alleged incident. Following that, the parents have been able to agree some arrangements, and those arrangements might be in place for 2 or 3 years, maybe longer. And then something happens that means the parents' relationship breaks down and the contact then breaks down, or whatever the arrangements are. Yeah. And that parent with whom the child is spending most of the time will go back to the allegations that happened 3 or 4 years ago. And in that instance, a judge is likely to say, well, if you were really concerned, you wouldn't have allowed the child to spend time with that parent over this period of time. It obviously depends on the circumstances and probably the severity of the allegations, but it does raise questions as to how serious did the parent think that these things were if they allowed the contact in the interim.
Yeah, that's right. And some of the triggers that we see for that. So you said there might be an event which occurs, which could be sort of related or not, but then it goes back to the old history, unfortunately, for good or for bad. One of the triggers we often see is where a new partner comes on the scene, because we're all entitled to move on with our lives, you know, if those circumstances arise. So parent with new partner. And one of the presumptions that is often raised is that if they've got a new partner, well, then automatically the partner should not be having any contact with the child. And understandably, there may be some reservations. They need to know that that person is, you know, a decent person to be around their child, whatever that may mean. But it also comes down to a lack of trust in believing that their previous partner, their former partner, would actually make the right decisions in terms of who they're with.
Yes.
And also sometimes, I don't know about you, Sarah, but I'm asked, is there a set period of time before my ex is able to introduce their new girlfriend or boyfriend?
Yes.
No.
But again, I guess it goes back to looking at the situation. So if somebody has had a series of partners, then that haven't lasted that long, then you would expect them to show that this latest partner who they want to introduce to the children, that there's some longevity to their relationship, because it's not good for children to keep being introduced to new partners who are then out of the picture. So it is better for it to be an established relationship that you know is going to have some last to it. But as you say, there's no set time and there's no one cat fits all.
No, and a lot of it comes down to common sense, doesn't it?
Yeah.
Just humans, we're not always great with that, but but that's some of it, isn't it? And again, communication and understanding. If you've got that relationship with your ex or former partner, then hopefully you can talk it through and be open about it.
Yeah, and I know on a personal level and from clients that sometimes one of the parents will meet with the new partner before the children are introduced, and actually a lot of people say that's quite helpful, and they feel reassured by that, and at least it's all up front and it's open, and that's got to be best for the children. If the parents have got an open relationship even though they're not together, that has to be in their best interest.
Definitely.
Yes. So in terms of control, because I know we touched on that previously, it's probably important to at least briefly touch on parental alienation. Sometimes it is raised within proceedings, whereby one parent with whom the children are living tries to prevent a relationship with the other parent, and it may be through making lots of allegations and dragging out proceedings. It might be just not complying with the order, or always saying the child's ill, or just creating problems in that relationship. It used to be the case that the court had the power to move where the children live for most of the time, but they very rarely use that power. But within recent years, there has been a big shift to recognise that Children Act proceedings, private law Children Act proceedings, are always based upon what is in the best interest of the child.
Yes.
And it may be, and moving the child from one place to another has to be weighed against the child losing a relationship with one side of their family because contact is being prevented. And now the assumption is that the judge would move the arrangements if a parent is being obstructive and alienating the other.
Yes. Yeah. And that's got to be in the best interest of the child, hasn't it? Because if you have got a parent who is being hostile and obstructive without good reason, and sometimes you've got to dig a bit deeper to find out, but if it is really without good reason, because maybe it's based on misconceptions, previous history, lack of trust, all of the residual stuff from that relationship breakdown, but not actually about the children, then you've got a situation which is detrimental to the child. And, you know, you may then have a position whereby if you've got a parent who's not having the majority or even a shared amount of time with the child, but they are willing to ensure that the existing living with parent does have contact if the children live with them. So if there was a swap, then in fact they would say, do you know what, I would let you have the contact. I'd be happy to facilitate that. Let's work together. And also I would include the extended family on both sides as well, because I know that's what's best for the children. Then you can see why the court would think, well, actually, that's a real positive. Because, you know, that's putting the children first rather than your own personal situation or misgivings about the other person.
Yes, yeah, and it was very much that moving residence previously, I mean, using the temp residence because that was what it was at that point, was a weapon of last resort. But you would find that it was used so rarely that you would end up with a series of proceedings because one parent wasn't complying and was obstructing the arrangements for the other, that children may be subject to proceedings for several years, and that can never be best for the children. And so that again needs to be brought into the consideration, and it was made clear in a recent case that moving a child from one parent to live predominantly with the other and making that decision that is in their best interest is a much lower threshold than for care proceedings, where it has to be that the child is at risk of significant harm to move to a foster carer. It's not the same moving to another parent, and it is weighing everything up as to what is best for them.
Yes.
So I think what we really take from this is that all of Children Act proceedings are centred on the child. And it doesn't really matter what the feelings between the parents are. If they can work together, that's great. But it's coming up with arrangements that work for the best interest of the child.
Absolutely. And it's thinking about how your family actually conducts themselves, how you operate as a unit, and also, you know, what you know about the other parent, but in a positive way, in terms of your respective strengths and working together, and really just facilitating something that would make sense for the children and be something which would create a happy environment, a combined environment. So in some respects, it's really sort of looking at it from the emotional perspective, but also as a working relationship. How would you actually put this plan into action? And that's when sort of parenting plan agreements come into place as well, don't they? Where parents actually sit down and say, look, this is what we're going to do. And there has to be flexibility, and there has to be scope for changes as children get older and things just move on.
Yes, yeah, absolutely. And as should be coming through in all of these podcasts, where people can work together and come up with a solution, it is usually best for them, because everybody's family is different, and the arrangements that work for you won't necessarily work for me. So if you can sit down and work those out together rather than it being imposed by a judge, it is going to be much better for everyone. Equally, it is better for the children if they see that their parents work together even though they're not together in a relationship.
Yes. Yeah, most definitely. And there's nothing more polarizing, sadly, than one parent having an order which they can wave around and say, you know, I won, or something of that nature, which is so unhelpful and so not the case. And much better to not even have to go down that road in the first place.
No, absolutely. Well, I think that's covered everything from my point of view in terms of the Children Act. Next time, I think we'll be looking at behaviour in domestic violence cases. We'll probably take a break for the summer holidays, so there's actually somebody around to watch these podcasts, and then we'll be back in September. Okay, thanks very much for watching.
Oh, lovely. Thank you, Sarah. Thank you, everyone. Have a good summer.
Yes. Bye.